Shock of shock. The anti-gun community is trying to exploit the gun-free zone loophole, which is known as the sensitive places loophole, to take away your gun rights, saying that, yeah, you're allowed to carry a gun in your state, but guess what? We're going to ban all the different places that you might actually want to carry a gun or need to carry a gun under the so-called sensitive places doctrine. The good news is that this was anticipated. In fact, we talked about this on channel literally months on this channel before the Bruen decision came down. I told you this is where the anti-gunners were going to go, but I thought that the Supreme Court was well aware of this is what was going to happen, and they were going to head it off at the pass, which I think they did, as I explained in a detailed scholarly article in the Harvard Journal of Law and Public Policy just a couple weeks ago, which I'll link to down below. Stay tuned and understand why the sensitive places argument by the anti-gunners is going to fail big time. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so to show your love of the right to keep and bear arms, and follow us on Twitter at Four Boxes Diner. We're working hard on social media to spread the word about this channel. Okay. No shock here. The anti-gun community is trying to use the media and use different arguments in the courts to try to expand the definition of gun-free zones or sensitive places, which are places where legislative bodies or regulators can ban guns, meaning they just say, yeah, you can have a concealed carry permit, but we're not going to let you bring the gun to church, and we're not going to let you bring the gun to the school, and we're not going to let you bring the gun here or there or to the store or restaurant or bar or whatever. Okay, no shock here. So there's a big story today in a CBS News report talking about how, oh my God, no one knows what a sensitive places is. This is a huge issue. We're so confused. We're going to spend a lot of time, figuring this out. And they're quoting all these different people. Ha 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 ha. Here's the reality, folks. I predicted this, and I'm going to give you the answer that you can take with you, and you can help spread the word about why this argument about sensitive places is ultimately going to fail and blow up big time against the anti-gunners, notwithstanding their attempt in various scholarly ways, including in op-eds and editorial pages and news reports like this one from CBS, because it ain't going to work. Let me explain why. Several weeks ago, I published a major article in the Harvard Journal of Law and Public Policy, which I'll link to down below, that lays out in extreme detail exactly how courts, litigators, and law clerks involved with Second Amendment cases should understand the meaning and significance of NYSERPA versus Bruen and how to apply it, including to issues such as sensitive places. The Harvard Journal of Law and Public Policy asked me to publish this and asked me to write this because they knew that by getting a critical scholarly voice out there fast, foremost and fast, it was going to provide proper, accurate guidance to lower courts to make sure that, people don't go astray or get, basically, screw up the application in ways that would be unfortunately harmful to our rights as Americans under the Second Amendment. So that's what I did. And I made it very clear, and I think everyone will agree with me that can be, an honest broker, as I see it, a serious scholar looking at this issue, that the United States Supreme Court made very clear what are sensitive places, and they all relate to specific important governmental functions. They don't touch on anything in the private sector whatsoever. They specifically deal with government. Let's not talk to Mark. Let's talk to the U.S. Supreme Court for 1 second. What are gun-free zones that people can create? Remember, they don't have to create gun-free zones. They may, meaning what the Supreme Court said is, a state of Wisconsin doesn't have to have gun-free zones or sensitive places. It's up to them. But if they wanted to do so, there's some very narrow and specific examples of how and where they can do it. What are those examples? They're very easy for you to remember, and I want you to remember these because there's really only 4 of them you got to remember. Just 4. That's it. And they're very common sense. Here they are. First, government courthouses. They said that you can ban guns in courthouses. That's a sensitive place because historically that was the case. Why? Because bailiffs showed up with guns and protected you in your life with government guys with guns at courthouses. Therefore, they said courthouses run by government are sensitive places. You can ban guns there because the government will take care of you in that particular instance. So again, courthouses is the first sensitive place, government courthouses. Number 2, government legislative chambers. That's like the United States Capitol, where legislators meet to pass laws. Again, a government function. So a state capitol house, where the state assembly or the House of Delegates or the state Senate, where they meet. Legislative chambers, government passing laws. according to the Supreme Court, historically, it can be, doesn't have to be, but can be a gun-free zone or a sensitive place. So again, we have courthouses, legislative chambers, 1 and 2. So what are the other 2 examples? The Supreme Court says polling places. Polling places. What is polling places? Well, polling places, again, you don't have to ban guns. You can ban guns under the history of the Constitution. And what are polling places? Those are places where people come and vote for politicians. They vote for government representatives. So you can, but don't have to, but you can ban guns in polling places. The third are schools, presumably government schools. Now, the example the U.S. Supreme Court cites to an amicus brief by an organization called the Independent Institute in California. And this amicus brief laid out in detail the history of sensitive places and how narrow they were and not broad. Now, what this brief said, and the Supreme Court cites to this brief in the Bruin case, they point to schools, but they don't just generically point to schools when they cite this amicus brief. What they specifically say with respect to schools is that at the time of our founding at the University of Virginia, in Virginia, guns were banned for students only. Again, at the time of our founding, with Thomas Jefferson on the Board of Trustees at the University of Virginia, guns were banned on campus for students only, but the adults, the faculty, the teachers, the administrators, whatnot, were all allowed to have guns on campus at the University of Virginia at the time of our founding. They prevented the students from bringing guns on campus. By the way, that was because there was concern that in the South at the time of the founding, they would engage in duels of the sort of thing that Alexander Hamilton did, and they were concerned that they had young men on campus with guns. There would be too many duels going on in the South, and therefore UVA says, yeah, sorry, if you're a student, don't bring guns here because we don't want you having too many drinks and dueling. We don't want that to go on. And that the Supreme Court, again, signed to that amicus brief by the Independent Institute, basically adopted that view. So again, the 4 sensitive places, and there's only 4 that the Supreme Court has indicated are, again, courthouses run by government, legislative chambers run by government, polling places all about government elections, and schools specifically with respect to non-students, because again, students could be banned from carrying guns on campus, but not the adults because of who the Supreme Court cited to in the NYSERPA versus Bruin case. Okay, I hope this helps because we're going to see a lot more articles like this article I just read this morning from CBS News talking about sensitive places and why it's a big litigation topic and why these, states like New York and California are going to try to define everything as a sensitive place if they can get away with it. The reality is, though, as I point out in my Harvard Journal of Law and Public Policy article, which I have a feeling is going to be read by a lot of folks, and I have a feeling will be quite influential going forward as to how this case gets applied. The truth is, sensitive places, gun-free zones should be, and I think will be, narrowly construed against the anti-gun movement, and I think that's great news for our right to keep and bear arms here in America. Okay, I hope you learned a little bit something today. If you haven't subscribed to the 4 Boxes Diner, please do so, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.